This is Closely Held. Thanks for listening. Today, we're going to discuss goodwill, which is a phrase that refers to the reputation and expectation of future business and sales for particular goods or services. It's the inclination of the public to do business again with a particular company and to buy more products and more services. The issue that we're going to focus on today is who owns the goodwill. Is it an individual with a great reputation? Or is it the business that the person works for? Often it's both. And we're going to talk also a little bit about how to protect that goodwill and how it impacts the value of a closely held business. My name's Jay McDaniel. I'm the head of the business divorce practice group at the Wiener Law Group. I practice in New York and New Jersey. Please take a minute to like or share this video and to subscribe to the channel. And if you have questions, there is contact information here in order to reach me. Goodwill is the revenue for service-oriented businesses. It's the intangible asset that goes beyond physical assets. And goodwill is responsible for the expectation of continued customer patronage. But here's the big question. Does it belong to the business, or does it belong to the individuals who happen to work for the business or own the business? Some examples. We have lawyers who are prohibited from any restriction on competition. We have a real estate management company where each principal of the management company works his or her own book of business. We have a design build firm where one principal generates the majority of the business. Or we have an outside sales organization where owners divide profits based on origination. Now, all of these examples raise the issue of who owns the goodwill. Who is responsible for the future earnings capacity of the business? And I have to say that this is an issue that is becoming even more important as the sentiment of the government and the public is turning away from enforcing traditional agreements not to compete with employees. The simple fact is that a business, especially a service company that has no economic moat around its business and which has not accumulated its own goodwill, is going to have a problem, potentially. If anyone, including the owners, can leave at any time and take the customers with them, that imminent competition that's out there diminishes the value of the equity in the business. Goodwill, again, an intangible asset, but it can be bought and sold. It's the reputation that goes beyond the physical assets. Now, you get into cases, however, in which a company benefits from goodwill, but what if the goodwill is not an asset of the company? In a case from some 25 years ago, the U.S. tax court held that goodwill belonging to an individual is not a corporate asset when the employee has no employment contract with the corporation. This means that personal relationships and assets can very well be distinct from that intangible corporate asset of corporate goodwill. Today, courts will distinguish between enterprise goodwill, that's enterprise owned by the company, and the personal goodwill, that's goodwill that's owned by individuals who are affiliated with the business. This issue often arises in decisions about the assets that have to be divided in connection with the divorce. Enterprise goodwill is included in the distribution of marital assets in most states, while personal goodwill is not. The distinction between personal and enterprise goodwill also comes up in income tax disputes, and it comes up in business transactions. It's important to determine whether the goodwill, that reputation, will continue without the individual. It's important to determine whether the goodwill will continue without the individual still being involved in the business. This can be an easy call with professionals, businesses like lawyers or accountants, where people tend to follow particular individuals, but it can certainly blur in other sales-driven businesses. Business governance documents, things like operating agreements and bylaws, can often overlook the critical issues of assigning the ownership of intellectual property to the enterprise. That assignment of the goodwill to the enterprise is something that's critically necessary to prevent departing owners and employees from leaving and taking customers with them. What happens when somebody leaves and there's no clear contractual arrangement as to who owns the goodwill. This leads to disputes about the value of the business and the intangible assets that it actually may or may not own. Valuation experts will often get involved in these disputes, and they take different approaches to address the issue of personal goodwill. Some valuation experts will look at the goodwill of owners and deduct it from the intangible assets of the business. So if somebody's responsible for generating half of the business, they back that out when they're doing the valuation. Other valuation experts will attempt to estimate the probable loss of sales due to the withdrawal of a rainmaker from the business. Now, the hard fact is that competition decreases the equity value of a small business. If an owner can leave and still hold on to the customers from their old business, that value of the old business is certainly going to decrease. As I said before, state legislatures and the federal government are making it much less certain that businesses can use contractual limitations on competition to protect the value of the owner's equity. If this trend against enforceability of agreements not to compete continues, the metrics of valuing a closely held business are likely to change. This could have a detrimental effect on the current generation of business owners. That's something that we'll talk about from time to time here on this channel, Closely Held. So don't forget to like this video and subscribe to my channel for more business-related content. Thanks for watching. I'll see you next time.